So you now know why I couldn't refuse when Denny asked me to do this presentation on wills. You'll see it's entitled Wills and Estate Planning. The estate planning is in small writing because we had an argument about that. I said the estate planning, the planning for the will is actually more important than the will itself. The will just writes down what you planned and what you've agreed to do. So I got away, but only in a small case. Most people will spend more time planning their annual holidays than they will planning for their will and distribution of their estate. I like to tell people it's about like you decided to go on a holiday to Broome. That's quite a reasonable thing to do in these times because we can't go anywhere else. And you've got to do a lot of planning. Are you going to fly to Broome, take the bus, drive the car? Are you going to take your wife or your girlfriend? Are you going to take all your kids, even the 16-year-old daughter who would rather be seen dead to go on holidays to Broome with their family? If you're going to take the car, do you need new tyres? Does it need to be serviced? Are you going to stay on the way up or try and guts it out and drive all the way through to Broome? If you're going to stay in Broome, are you going to stay in a fancy Cable Beach resort or in a caravan or in other accommodation? There's a lot of planning goes into, and each of those steps logically follows the other one. All right, I'm going to take the car. Yes, I need new. Yes, it needs to be servicing. Yes, I need 2 new tyres on the front. That your estate planning is the same sort of process. You've got to start at the beginning, work your way right through to the end. When you get to the end, hopefully in agreement with your spouse or partner, then you get it drawn up by a lawyer, preferably, or drawn up by yourself if you're willing to take your life in your own hands. The other small writing on the bottom is pretty much correct. The figures are quite clear that slightly less than 50% of Australians will have a will. I'm not talking about kids and dogs and cats. I'm talking about 50% of people over 18 or 20. And a large part of those people die without a will. Now, the last line is pretty much it. They ask you to put your hand up at lots of speeches. If anybody thinks that last line's wrong, would you please put your hand up? Right, so we all agree that we're going to die. You inevitably are going to be in that 100%. It's going to die. What you don't want to be is in both of those cohorts. You don't want to be one of the people that die without a will. And that's what I'm going to try and talk you through today. So, if you die tomorrow, what would you like your affairs to look like? What would you like? The distribution of your assets, how would you like that to happen? And you're still able to do something about it right up until the time you lose cognitive ability or the time you die. So the time to make those decisions and do that work is now. What can happen if you don't have a will? You'll have no control at all over how your assets are distributed. People you want to benefit may not benefit under the distribution. People you never intended to benefit may also end up with some part of the assets. You could lead, such a situation may well lead to fewer family disputes between those you leave behind. And a child with greater needs than the other children, or a child with special needs may miss out. You'll see I've missed out line 2. Assets will be distributed in accordance with the Administration Act of Western Australia. That act, and each state has a similar act, specifically designed, was designed in 1925, specifically designed to deal with what used to happen, how estates have been distributed for people who die without a will. Remember, that's 50% of us. And it's quite a complex act, and it's quite prescriptive. There's a lot of community misinformation out there, urban myths we call it, that if you die without a will, then the government gets all your estate. That's absolutely, completely untrue, except for when you get right to the end. So in the Administration Act, there's a table in section 14 of the Act, and that table is very prescriptive, and there is 11 categories of how you might die and who you might leave behind. And I'll deal with the first one or two, and we won't go through the 11, and then the very last one, because that's quite interesting. If in the estate, if you die leaving a husband or wife, whether or not the surviving husband or wife shall be entitled absolutely to all household chattels, including property. So husband or wife gets all the furniture. And he goes on to say, if you leave a husband and wife at issue, where the net value of the property doesn't exceed $50,000, the surviving husband and wife gets all of that $50,000. It used to be $5,000, and upped it to $50,000 now. Where the net value of the estate exceeds $50,000, the surviving husband or wife gets the first $50,000, then they split everything else that's left into three parts. And the wife gets one of those, and the wife or husband gets 1/3. So all the chattels, $50,000 and a third of what's left, and the kids get the other 2/3 split equally between them. And then it goes on to section 3, if you die leaving husband and wife, and one or more parent, brother, sister, child, or brother or sister, but leaving no issue, that's no kids, then X happens. And then it goes on and on and on. If you like, you die leaving no husband or wife, no issue, parents, brother, sister, child, or a brother or sister, but leaving a grandparent or grandparents, then they get it. And right through, we get right down to situation 11. Basically, it means that if you die with nobody, not even dogs and cats, then the government gets it. If you die leaving no husband or wife, no issue, no parents, brothers, sisters, child, brothers or sisters of child's, grandparents, uncles, aunts, or child of an uncle or aunt, the whole of the intestate property passes to the Crown. So it's catered for. You don't need to worry particularly about your assets going to the state unless you've got nobody. The objectives of your will should be fairly straightforward. You need to pay all your debts and funeral costs and taxes, all your other liabilities. That's the first call on your estate. And you probably want to make provision for your spousal partner. If you're not going to do that, I'm going to say don't tell them you haven't done it. Then you want to distribute your assets according to your wishes, and you want to maximise the amount that you're going to leave to your children. Once having crossed the Rubicon and decided to leave your kids something, then you want to probably make sure you leave them as much as possible. If you have a relative or a child with special needs or disability, and they may not be a mental or physical disability, you may have a daughter that made an unfortunate marriage. She's got 2 children under 4, husband's a gambler, and they've separated, and she's struggling. She's living in a council flat, living on a supporting parents' family. You may well want to leave her a larger part of your estate in the husband, the son who's an airline pilot, and the daughter who's a brain surgeon. You also need to consider whether you're going to make a special provision and appoint a guardian for children under the age of 18. That's not going to worry many of us with, but you can appoint a guardian in your will for minor children, and guardianship expires at 18. So you can't appoint a guardian for your adult children. You need to consider very carefully who you're going to appoint as your executor, because that person needs to have some commercial nous, preferably it's somebody that you know well, that is younger than you, and who you can trust to administer your estate, perhaps over the next 2 or 3 years, or if you leave assets to very young children or grandchildren, that executor may be administering your estate and managing those funds and investments for as much as 15, 18 or 20 years from the date of your death. It needs to be younger than you, or me anyway, and it needs to be somebody you trust to do that in that period of time. If not, then you seriously need to consider whether you should appoint a public body to do it. And the logical person in West Australia is the public trustee. And They are reluctant to do it because it's a lot of work and it really doesn't pay them. They much rather administer estates that are very large, but they will do it if you have nobody else. One of the big things to consider nowadays is how much superannuation you have and where will it go when you die. When I was young, people like me weren't even allowed to have superannuation, and they changed the laws in the 70s. We could put 15 as self-employed governments, judges had it, but not ordinary men in the street. Then they changed the law so you could put $1,500 into superannuation, which we thought was a big step up. And then they increased that to $3,000, and eventually we got universal superannuation in Australia. And for people like us, that's built up and it may be a reasonable sort of sum. But for young people that have been or will be in the superannuation system for 25 or 30 years, 40, 50 years, their superannuation will equal or exceed the value of their house. So young people I see now, or even, so what's middle age nowadays? Middle age keeps moving as you get older, but I'd say 55, 60-year-olds I meet now often have 6, 7, 8, $1.2 million in superannuation and a house worth $6, 7, 800,000. So the superannuation is a bigger asset as is your family home. And so that's something I'll get to a little bit later on, but you really need to take that into consideration and discuss it really carefully with your lawyer, accountant, or financial planner. Other things you need to consider, of course, are do you have an enduring power of attorney or an enduring power of guardianship in place, and do you have an advanced health directive to govern what you want to happen to you in the last part of your life if you become that ill. Assets can be included in your will are just exactly as they're listed there. Some things that you may not be aware of, in that you can leave shares in your family company to any beneficiaries that you so choose. Any powers of appointment you have under a trust or a gift, you can usually pass on that power of appointment to somebody else in your family, and some insurance proceeds will be included in your will if the insurance policy is such that upon your death, the proceeds go to your executor or your estate. Those will be assets in your will. What can't you leave in or deal with in your will is something that you really need to be aware of, and a lot of people are not. If you buy a wills form from the local IGA or post office, it won't tell you any of this sort of stuff. Your superannuation is not considered to be your asset. It's not able to be dealt with in your will, except for certain circumstances that are too complicated for us to worry about. You can't deal with your super in your will. But when you die, if you haven't made any other provision, the trustees of your superannuation fund have a discretion as to where they distribute those funds. They usually distribute them sensibly amongst your spouse or children, grandchildren, usually spouse and children. But it may well be that you do have two spouses, one that you haven't yet been divorced from, and a partner, a de facto partner. And that's quite more common nowadays than when I first started law. And you really need to come to grips with that, talk to your superannuation providers, and make a thing called a binding death benefit nomination. Those death benefit nominations then get filed with your superannuation provider, and they will nominate what you want to happen to your super when you die. And you may nominate 50% of your super to go to your spouse and 50% to go to your legal person representing, which is actually to your estate. And then it will be dealt with in accordance with the terms of your will, but you can't deal with it in your will. Any assets you hold in joint tenancy are not dealt with in your will. Joint assets held in joint tenancy, particularly property and joint bank accounts, automatically, the minute you take your last breath, then belong to the other joint tenant. So if you and your husband own a house as joint tenants, you can't leave your house, your half of that house, to somebody else. It will automatically, on your death, go to your husband or partner, the other joint tenant owner. Same with the bank accounts. If you want to change that, then you need to change the joint tenancy provisions from joint tenancy to tenancy in common. It's fairly straightforward to do. Husband and wife as joint tenants transfer the family home to husband and wife as tenants in common. There's no stamp duty on that. It will cost you a little bit of legal fees and a little bit of lodgement fees, but you should be able to do that for $100,000. You then can leave the other half of the house to your children or whoever you want to leave it to. And often I get relatively wealthy families from western suburbs who have grown-up children, and the wife will say to me, what if I die and he gets a Russian bride, then my kids are not going to get any of it. And I said, well, if that happens, you're both joint tenants. When you die, he will own the whole of the house. And in those cases, 2 or 3 times I've changed the tenancy from joint tenancy to tenancy common. And I've yet to meet any of the Russian brides. Life insurance proceeds, as I say, if the beneficiary life insurance policy is actually your estate or your legal person representative, those assets could go there. But you can have a life policy where the beneficiary is a named person, so children, parent, spouse. Particularly in a partnership with partners, like a commercial partnership where partners insure each other's, then in my legal practice, we all insure each other. So if one of us died, the proceeds of our life insurance policy went to the other partners. We had an agreement that they used those proceeds to buy my share of the partnership, so they didn't have to deal with my wife and vice versa. And that's really common in medical, legal, and veterinary accounting practices. Assets held in a company. You might have a family company, the family company might hold a large number of assets, investments, and your family business. You can't leave those assets in your will. They're not your assets, they're the company's assets. All you can do in your will is leave your shares in the company to whosoever you wish to leave those shares to. And you can make directions as to what you want to happen, but those directions are not binding unless you write it into the articles in the constitution of the company. Similarly with assets in a family trust, family trusts are pretty common nowadays when people are running and operating businesses or farms, and those assets in the trust, again, don't belong to you, they belong to the family trust. You can appoint your will, hopefully somebody else to act as trustees, and hope to give them directions to comply with your wishes. Those directions are indicative, but they're not binding. So those are all tricky sort of issues for people who are complicated, sophisticated business, financial, family affairs. But you can choose to leave no assets to your children. If you look what's happening with people like Bill Gates, they're leaving their children a modest amount of their billions of dollars and doing good work with the rest. So you may well feel that if you've given your children a good education, helped them buy their first house and looked after it by and large, left them a bit of money for the grandchildren's school fees, that they don't need any more. And that's a very legitimate decision to make. You may spend a whole lot on a ski holiday. Every time I come back from Manjimup, we pass literally hundreds of very fancy caravans being drawn by very fancy large four-wheel drives. And those people are not going to leave their kids too much. You can leave the assets to the beneficiaries as an outright gift. So there's no strings attached. I leave each of my children 1/4 I say, I leave each of my children $500,000, $200,000, and I leave the rest to St Mary's Church of the Latter-day Saints, or whatever. I don't think St Mary's was in that. You might leave some assets to other siblings if they're doing it tough, or that if you received a large inheritance from your parents, you might feel compelled to keep that within the family circle, leave something to your children. Another serious option, if you have beneficiaries, children or family members with a disability or a vulnerability, you might leave a gift to them to be held in trust. So that means you will not, that person will not get the asset. They will have the benefit of that asset. Somebody else will hold it on their behalf and administer it, invest it, so that the vulnerable beneficiary or the 3-year-old grandson won't have access to that either at all or until they get that. Means I've got to go faster. Is that 25 minutes already?
No, 5 more minutes.
Oh, I've got thousands of things to say here. You should maintain your will at least every 5 years. I'll just tell you a quick story. I was a young lawyer from a farm, used to work in shearing teams. And at about the age of 21, I was working in a shearing team down in Franklin. Shearer come up to me and his name was Ron Maisie. And Ron said, "Hello, Smarty, you're a lawyer, can you do me a will?" And I said, "Ron, I'm not a lawyer, I'm a final year law student." He said, "That doesn't matter, do me a will." So I went and got a piece of scrap paper and sharpened a pencil, and we sat down on the wall rails, on the boards of the shearing shed. I wrote him out a will. About 10 years ago, which would be nearly 40 years later, I got a call from Lisa. She said, "My name's Lisa Maisie, you won't probably remember me." I said, yes, you're Ron's wife." She said, "That's right. I was just ringing to tell you that Ron died, and we can't find anything that resembles a will except an old piece of paper written in pencil. It's witnessed by you, and one of his shearing mates said he seems to remember you doing that in the shearing shed." So luckily that will left everything to his wife, and if she didn't survive him, then everything equal to his children. His wife had survived him. They found the will and was still valid. But I reckon you should review it more often than every 40-odd years. So update your will if circumstances change, if there's a death, divorce, marriage, if you have grandchildren, or the circumstances of your children change, then you should again review your will. What's a trust and why you may need to have one? A testamentary trust is quite simple. Your will is actually your last will, testament. A testamentary trust is a trust that's set up in your will. You might say, "I leave $60,000 to each of my grandchildren, Bill and Bob and Bernice, to be applied towards them attending the first 3 years of school at John the 23rd. And that will be a trust. And those funds must be held by the trustee, usually your executor, and they must be applied in accordance with your wishes. And if the children can't get their hands on them, they can only be used for school fees. You should, in your trust, make some provision as to what's happened if the children die or if they don't wish to go to high school. There are lots of different types of trust. Discretionary trust is a trust that some of you will have come across and will have operated your business through, and that's used to distribute money for tax purposes between the beneficiaries. Testamentary trust is something you set up in your will, and it can be as broad or as narrow as you want it to be. Special disability trust is another creature altogether, and it's quite complex, but it's an extremely useful form of trust set up by the government to make provision for a child, grandchild, person with a disability. So you could have in the special disability trust a house to any value and assets up to about $680,000, and all of those assets in the house, provided the child lives in the house, the person with a disability, none of that house nor those assets count towards the asset limit test, or the income limit test for especially for your support pension. So it's a very, very handy thing to put in place if, in fact, you have something like that in your immediate family circle. The role of the trustee is quite complex, and you need to manage the trust assets and the estate, and well, you can read that as fast as I can speak about it. Always annoys me when you're in a thing because you can read it and then the speaker keeps going for another 5 minutes. But the trustee's role is quite an onerous one. I wouldn't take that job on unless you know somebody really well, unless you think you've got a good 20 years left. Choosing a trustee is very important. It's just as much it's just as important a job as choosing your executor. Sometimes you can use the same person as your executive trustee. So once the executor finishes winding up your estate, distributing all the assets, he morphs into a trustee. So the assets that he's holding long term, he then holds as trustee. So you'll hear people spoken of as the executor and trustee of my estate. They can be the same person. They magically change from one to the other, like a You set up a discretionary trust at any time, testamentary trust in your will, and a special disability trust, either now to make provision for a vulnerable beneficiary or in your will. In summary, you need to periodically, realistically review your estate. It's no good saying, well, I've got all these assets. If on the other hand, you've got $1.2 million worth of assets, you've got $1.3 million worth of debt, then you're in strife. So you really need to realistically review your estate, know which of those assets might be subject to taxation on your death and sale, and then you need to have a vision of what you want to happen. And against the vision, you should have another picture, put it down on paper. You should then have another diagram of what is the reality. And the gap between what is reality and vision, what you would like to happen, is the gap. And you need to think, how am I going to bridge that gap? For younger people, it may well be, I can bridge that gap with life insurance. So if I've got $400,000 or $500,000 mortgage in my house, with small children, I will need a $400,000 or $500,000 life insurance policy. If I die, my wife gets $500,000, she pays off the mortgage, she can stay in the family home, the kids can continue to live in the family home, they can go to the same school, they've got all the little mates in the same suburb. I've seen this dozens and dozens and dozens of times over 46 or 7 years of practice. The widow that comes into me, whose husband had decent life insurance, can manage. The woman that comes into me and says, look, my husband had messy business deals, he had $400,000 or $500,000 worth of debt in the business, we've got a $500,000 mortgage over the family home, help me. It's too late. It's too late. So make sure you identify the gap between your vision and reality and manage it. And we're getting close. It's essential to review your situation regularly and look at your assets and liabilities and see whether the provisions you've made in your will in terms of where everything's to go is still appropriate. Do those children still need those assets? Has your sister that was really struggling married well and no longer needs your help? So every 5 years at least, get your will out, have a look at it, discuss it with your partner or spouse, say, is this really still what we want to happen? You may not need to change it, but check it anyway. Thank you very much for your attention. You will have in your bundle a really handy little thing called Wills and Estate Planning, your essential checklist. That's not to scare you. That's just an aide memoir, as they say. If you go work your way through that and ask yourself, can I answer each of those questions? Am I able to answer each of those questions in the affirmative? Then you're probably in great shape. If there's gaps in what you see there, then you need to talk to somebody and make it well. I'm going to talk to you about enduring powers of guardianship and attorneys, if you're not sick of the sound of my voice by now. Jenny and I had a bit of an argument about this because she said, I said, get somebody else to talk about that. She said, no, you can talk about that. How long? 25 minutes. No, I can't talk about these sort of things for 25 minutes. It's a bit like washing the dishes. You wash the dishes for 40 years, you can't keep 25 minutes speaking about washing dishes. Powers of attorney and guardianship, it's just something you do, 2 pages. And then, lo and behold, I never allowed for Denny's persistence and intelligence because she started to look at these things on the websites. And they're actually a bit more complicated than I thought. Denny found a whole bunch of stuff that I didn't know. And I must give her credit for these slides because they are hugely comprehensive, very well put together. She sweated blood over them, and pretty much none of them am I doing. So Denny is responsible. Very good slides. I don't know how fast you can read, but there's only 245 slides. So keep reading really fast and we'll get through this. There's a couple of things that I really need to bring up, and I'll do that in due course. That's the only thing that Denny overlooked. I was so pleased to find something. Information is of a general nature and it's not personal legal advice. The world's word. The really good thing about enduring powers of attorney nowadays, and they're both relatively new to the law. In the old days, you could do a power of attorney or a guardianship, but they no longer took effect when you got dementia or lost your marbles or were unconscious. In the modern era, medicine can keep us alive much longer than perhaps we want to be kept alive or much longer than we should be alive. And often now, there are people in their 80s and 90s who are living in a state of suspended animation, really, for 10 or 15 years. And if you appointed somebody as your attorney and you had dementia or were unconscious, then that attorney couldn't act for you. So the government and the law has come up with a thing called an enduring power of attorney and an enduring power of guardianship. Those are enduring because they continue to operate when you've lost your mental capacity. There are certain differences, I'll talk about that. So that's what we're talking about. We're not talking about an ordinary power of attorney, we're talking about enduring powers of attorney. On the website, the government had really, the public Office of Public Advocate really put their shoulder to the wheel here. And on their websites, they have a wonderful amount of information in regard to enduring powers of guardianship and enduring powers of attorney. Those details are in one of your handouts. Google, go to those sites, and you can get pretty much all the information that I'm going to give you now. There are checklists there. There are pro forma documents that you can download or complete online and download and write in. Everything you need to know about and every document you need in terms of enduring power of guardianship and enduring power of attorney are there on those websites. So you don't have to get a lawyer. Lawyers will do them for you. Save yourself $150, $200 to do them yourself. There's lots of abbreviations used in the talk. I probably won't use the abbreviations because I hate the appointer is probably something you need to know about. If you are giving somebody a power of attorney or guardianship, you're appointing them. So you are the appointer. The person that gets the right or the liability to be your guardian or guardian or attorney is the appointee. SAT is the State Administrative Tribunal. I'll probably use that because the law got used to that. The State Administrative Tribunal administers both these sorts of acts and makes decisions in respect of management of people's lives and the appointment of administrations. A guardian is somebody that's appointed by SAT to manage your affairs, either because you're too young to manage your own affairs, or you no longer have the capability of managing your own affairs. If you don't choose somebody to be your guardian or your attorney, choose carefully. We went through this when we were talking about wills and trusts. That person will stand in your shoes to make decisions on your behalf and in respect of your assets and your life as if they were you. You need to have a lot of trust in that person, and you will see in the paper from time to time, of course, cases where people have taken advantage, particularly of elderly relatives with a few bob. So make sure it's somebody you trust, and if you don't trust them, particularly with the ensuring the other one. Yes, your enduring power of attorney. The enduring power of attorney deals with all your assets, your banks. If you're not sure that that person is trustworthy or they could be influenced by somebody else in the family, point two people, point them to act jointly. If you're a very complicated business affairs, family trust and companies and businesses, then consider carefully appointing your accountant or a lawyer as your attorney. They might not be entirely honest, but if they're not honest, their professionalisation usually takes away their right to practice. There are similarities between the two. You've got to be an adult to give somebody your guardianship or attorney. You must have capacity. Capacity is to some degree subjective, but there are guidelines in some of the other states, very, very complex guidelines about assessing capacity. If you are in doubt whether somebody who is giving you power has capacity, or if in doubt whether you yourself have capacity, speak to your doctor and preferably get your doctor to do a medical report to say you do have capacity, and give the people who witness your power of guardianship, or power of attorney to be people who have known you for a long time and that will testify, if necessary, that they knew you, they've known you for 20 years, and you had your full facility. In other words, you have capacity when you executed that and gave those powers. How must an enduring guardian or enduring attorney act? This is the only thing I think Diddy missed out. I'm so pleased to find it. She probably should store it, but I want to read you this because I think this is the kernel. People talk about the nub or the kernel of something, and I think these are perhaps the most important thing to understand when we're considering appointing somebody or taking that on. So they're set out. These duties are set out in section 51 and in section 107 of the Act. And they're not on the slide, so I'm going to read them to you. A guardian must act in the best interest of the represented person by, subject to any direction of the state tribunal, the guardian shall act according to his opinion of the best interest of the represented person. So you don't have to find some objective series of what's right and what's wrong. If you're acting in your reasonable opinion in what you think is the best interest of that person, then you should be all right. Without limiting that, the guardian acts in the best interest of the represented person if he acts insofar as possible as an advocate for that person. That is, basically they stick up for you, they protect your rights, they advocate. Be in such a way as to encourage the represented person to live in the general community and participate as much as possible in the life of the community. I had a recent situation. It was an extended family, but still family. where the wife no longer liked her husband, he got dementia, she just swapped him away on very short notice. On his 90th birthday, she moved him into a home without discussing with the rest of the family. That was a horrible situation. You are required to encourage the represented person to live in the general community. Thirdly, you've got to act in such a way as to encourage and assist the person to become capable of caring for himself and of making reasonable adjustments. So you've got to be proactive in trying to progress their affairs. You've got to act in such a way as to protect the represented person from neglect, abuse, or exploitation. And as I say, we're living for 10 or 15. When my grandfather was born in 1893, I think it was, the average life expectancy of an Australian male was 54. It's now 87. We're now living much longer than any generation ever in the history of the world. And some of those last years are not good. And so you've got to, as the guardian, protect the represented person from neglect, abuse, exploitation. You've got to listen to the wishes of that person insofar as they can be expressed. And you've got to act and in a manner, this is, I think, the key to the whole thing. You've got to act in a manner that is least restrictive of the rights while consistent at the same time with the proper protection of the represented person. So as a guardian and an appointment as a guardian and an appointment by SAT as administrator, you're taking away whatever. We are all assumed to have capacity. We're all assumed to be able to run our own affairs, make our own decisions, spend our own money on what we want to spend, go where we want on holidays. When you appoint somebody as guardian or administrator, you're giving away some of those powers, those rights. Once you lost your capacity, you've given them away entirely. The person you appoint, your appointee, has all of those powers and rights. And it's really significant. The Act specifically says you've got to act in a manner that is least restrictive of their rights. And this is another one too that are also very important, I think. You've got to act in such a way as to maintain any supportive relationships the represented person has. So you can't walk them away from the rest of the family. Take them to Sydney to live in an old folks' home where all the rest of their family live in Western Australia. There's all sorts of safeguards in this section 51 of the Act that are really, really important. And then the last one, again, I think is a really significant thing. You've got to act in such a way as to maintain the represented person's familiar, cultural, linguistic, and religious environment. So if somebody in your family has joined the Seventh-day Adventist Church, or is a Jehovah's Witness, or is a vegan, or is strongly of the Jewish or Catholic faith, you can't ignore all that. You've got to act in such a way as to maintain that person's cultural, linguistic, and religious environment. These are really powerful statements in that section. And I think they covers the whole of the rest of it, which is technical. This is all it's paper. These are the nut, in my view anyway. I think they're the nut of appointing and acting as a guardian. Similar stuff for...
Kerry, sorry, excuse me, but if you're going to read the whole of section 107 as well, we are going to run out of time and nobody's going to be able to ask a question.
No, you're right.
Okay.
The obligation of the donee is the person you appoint as your attorney. That attorney, remember, has all the powers over your financial affairs and investments and things like that. The donee shall exercise with reasonable diligence to protect the interests of the donor. If he fails to do so, he's liable to the donor for any loss occasioned by the failure. Now, there's a much more strict obligation. Specifically, you've got to do that. Power of guardianship, and then you've got what you believe is the best interest. This is specific. You shall keep and preserve accurate records and accounts of all dealings. So you've got to account to the rest of the family or the court, if necessary, for the money you've spent, how you've spent it. And you can't renounce that power of attorney. Once the donor loses his capacity. So you need to be aware that you're stuck with being that person's attorney once they lose their mental capacity. The only way of getting out of that is to go to the State Administrative Tribunal and ask to be released from that obligation, and the tribunal will appoint somebody else, maybe the public guardian or the public advocate. Right, then can I now go back to
Yes,
your...
please.
You must have full legal capacity. We've dealt with that to a large degree. Get your GP or qualified person to give you an opinion as to what capacity is. If in doubt, get on the internet, find really useful information from some of the other states as to how you judge capacity and what you should do to make sure capacity is sufficient. If you've got doubt, want to cover your backside, make an application to the State Administrative Tribunal and they will send you right one way or the other. If you're giving an enduring power of guardianship or an enduring power of attorney, it must be in writing, you must sign it, it's got to be dated, and it must be witnessed. The requirements are similar in both EPAs and EPGs, and all of the people that you appoint must accept, so they must sign to say that we accept our appointment. If they don't sign it, then the appointment's not valid. The acceptance of an EPG must be witnessed by two people, much the same way as the signature of the donor. Enduring power of attorney doesn't need to be witnessed, but you don't need to remember all this stuff now because it's all on the website and it's all on the forms that you will download and do yourself. You can appoint substitute attorneys. They must also sign the acceptance. So you can appoint somebody to, you might appoint two people as your power of attorneys, and they can be appointed to act jointly, so they must act together, or jointly and severally, which means they can act together, may act severally, individually, or you can appoint them a single person to act as a sole attorney. And you can appoint substitutes to say that if one of these people die, then I appoint this other person to take their place. All of those people must sign the acceptance. Witnesses got to sign. The witnesses to the signature of the appointor must be present and must witness him or her signing. So they all need to be together at the same time. The witnesses, the signing by the person who accepts the power of attorney and the power of guardianship doesn't have to be at the same time. So you can get them, you can sign your enduring power of appointment or guardianship, have two people there, witness them, and then take them away and get the two people that you've appointed to sign their acceptance at a later time. So that's fine. You've got no obligation to assess the capacity of the person making those appointments, but if they obviously haven't got capacity, it would be a very silly thing to do, to accept an appointment or to witness the signature. There's a major difference. So why have we got these two things that are sort of first cousins, but they're not really? The enduring power of guardianship deals with all your lifestyle. It's where you're going to live, what school you're going to go to if you're young, what nursing home you go to, what treatment decisions are made for and about you. And it comes into effect only when you lose capacity. So up until then, you make all those decisions for yourself. It's when you've lost capacity, you've got Alzheimer's or unconscious, or no longer can make those decisions, then that enduring power of guardianship comes into effect. you can choose to have an enduring power of attorney is different. You can choose whether you want it to come into effect straight away or when you go away. So Danny and I went overseas a couple of years ago, and I gave two of my kids, we both gave a couple of our kids enduring powers of attorney. So they could do whatever we liked. They liked. Luckily, they didn't do terribly much while we were away. Or you can choose to say in your enduring power of attorney that you don't want it to come into effect until such time as I've lost capacity. So you don't have one of the kids running around with the power of attorney spending money until you've lost capacity. And at that stage, if I'm not mistaken, that person then has to go to SAC and get an order that you've lost capacity. Is that right?
It depends on which box you tick in the enduring power.
Yes, but if you say you only want it to come into effect when I lost capacity, then if somebody wants to use that, they've got to go to the State Administrative Tribunal, satisfy the tribunal that you have in fact lost your capacity, and then that enduring power of attorney will come into effect. How again? Right. The attorneys can resign at any time provided the appointer still has capacity. If you've lost capacity, then the appointee can only resign by applying to SAC. Revocation, look, if you do a will, marriage, divorce, all sorts of number of other things will revoke that will. Marriage and divorce do not revoke an appointment of enduring power of attorney, enduring power of guardianship. So if you've appointed a spouse or a partner as your enduring guardian or administrator, and you change your spouse or guardian, better change your powers of appointment as well. It's just a good idea. There's no obligation to register either document. It's a good idea to make multiple copies and have them certified as true copies, and to lodge those copies with people who you trust so that somebody can find it when it goes wrong. If you want your power of attorney to be dealing with land or property, if it's likely that you're into your 80s and if you do lose capacity, if it's likely that you'll want your house sold and the money used to buy a bond in a nursing home, then you will need your enduring power of attorney to be registered with Landgate so that people can operate and sell the house. It's a good idea to do it at the time. If you don't, there's a bit of a rigmarole to have it registered. Store them somewhere where they can be found, especially amongst family members. If you've got a long-standing GP or healthcare provider, give them a copy as well. Where is an EPG effective? It's effective in Western Australia. If you move interstate, you need to check with the authorities. Unfortunately, each state has slightly different laws and regulations in regard to enduring powers of guardianship and attorney. The relationship between the two, why we got this?
EPG and AHD, just because they are closely related.
Okay, they're first cousins. And enduring guardian can't override clear decisions in an advanced health directive. So you've got a sort of a hierarchy, this is a really useful slide, I think. It's a hierarchy of what happens if you're losing capacity. At the top of that hierarchy is your advanced health directive. This is something that's fairly new. It's getting better. They're working on a new form. You'll be able to register that advanced health directive in the foreseeable future, and that will govern what you want to happen to you if you've no longer got capacity. It's too late to try and put that in place once you've lost capacity. You're stymied. So do your advanced health directive, get it in place, discuss it with your close relatives, spouse, and register it. The next important document is your enduring guardianship, and then your guardian. If you have no enduring guardian, then a guardian. If you have neither of those, then a spouse or de facto partner will be asked to make decisions. If you don't have one of those, an adult son or daughter will be asked to make decisions. That can be problematic because the children that have been nursing you in Western Australia for the last 6 or 7 years of your life know jolly well that you don't want to be kept alive, that you don't want to be on life support, and that you want to just be let go peacefully. The daughter who's lived in England for the last 20 years and feels guilty about neglecting their mum flies home to Perth because mum's like dying. And you can't be so cruel as to let mum die. We've got to do everything to keep her alive. So I've seen that happen a number of times. And it's part guilt, it's part the absence, but the people that are closest to you, that have nursed you through your terminal illness, they're the ones that know what you want. If you have parents or siblings, you haven't got them, your primary caregivers and other people, a personal relationship. Work your way through that, but I reckon you want to be in the first two lines, not any further down there. Thank you very much for your patience. Thank you, Denny, specifically for wonderful and very informative slides.
Thanks, Kerry.